we're going to go to the questions. And panel, we're going to do this. We're going to address the question to a specific member of the panel, and then we're going to allow everyone to weigh in if they have an idea that they would like to share about this particular point. So the first question is going to go to Stephen Schwarber. Stephen, can you discuss the process for how a renewable resource in PJM can be subject to the MOPR and still clear the market in more depth?
No, it's an excellent question, and I'm glad it was asked. So to clarify, the exact final rules and processes for these are still to be finalized. So procedurally, there have been a series of different compliance filings that have been submitted by PJM, and the final one still needs to be finalized by FERC. However, so everything you say, please take with that grain of salt. That the final procedures could still change, and PJM in terms of how it implements it still be exactly the same. But however, that being said, what will likely happen is that prior to submitting your offer into the market, there's a and prior to the auction, there's a pre-registration process for the auction. This has happened for all the auctions where you have to actually register your resources, put out the information to PJM. That sort of pre-auction window opens several months prior to the next auction, which is yet to be set, by the way. We're still waiting when the exact auction will be. There have been delays. So what will occur is during that pre-registration process, each resource, and it's called renewables right now, will be able to go and try to claim one of those. Well, there's several exemptions, but two of them, the most particular, most applicable for renewables. One is the competitive exemption. One is the unit-specific exemption. The competitive exemption is going to be a process where you'll have to submit an officer certification form, it looks like, and you're going to have to officer will have to certify effectively that they will disavow all state subsidies. Then they get what's called the competitive exemption, and they can, then basically offer a price not subject to the MOPR. The second process is going to be the unit-specific process, whereby you can go forward and actually construct a unit-specific MOPR price that is not going to be the default. So, for example, the default prices that have been calculated at PJM for different asset classes relate to, your CapEx costs, what your cost of value of equity for your investors. A lot of very detailed cost-based inputs inputs that go into how PJM calculated the default prices for each particular resource type. However, specific units can go in with supporting supporting affidavits, supporting information to justify a lower specific offer. That process is most likely how a lot of renewable resources may be able to clear the market, despite being technically subject to a minimum offer price. And so that's generally how it's going to work. This is something, as I mentioned, I've been advising other folks, on this process, how it works. It's been applicable, by the way, the unit-specific process to gas resources for several years in PJM's market and in PJM's capacity market. Now it's just going to be applicable to renewables in addition to all different types. So available to answer more detailed questions, but that's generally how the process will work.
And thank you.
At least how we expect it will work. I'll put that caveat in there. We're still waiting for FERC to finally finalize everything.
Okay, Stephen, thank you for that response. Would any of the other panel members like to weigh in on this point, or we'll go to a fresh question? Okay, we'll go to a question then Rebeja, for you. What standards or frameworks will the DOE rely on in terms of analyzing undue risk?
Sure, that's a great question. So the guidance that we've received so far from the Department of Energy, it's really through the request for information that was issued in July regarding how they are going to assess risk. And basically what we know is that they're going to rely primarily on pre-existing standards and frameworks to assess risk. In particular, the National Counterintelligence and Security Center's supply chain risk management framework. And the DOE is likely also going to build on existing guidelines and standards such as the National Institute of Standards and Technologies publications, and also the critical infrastructure protection reliability standards that are developed by NERC and approved by FERC.
Okay, thank you, Rebeha. Anybody want to add to that response? Any other thoughts on that? All right, then, Stephen, we're going to go back to you with a fresh question. Stephen, can you explain how the FRR option may work in PJM if states elect to utilize it?
A great question. So the FRR construct is a fixed resource requirement. It's actually something that is technically available today under PJM's tariff. And there are some utilities that still utilize it. And without getting into too many details, effectively what happens is that rather than a utility or load serving entity relying on the general capacity market to procure resources, serve load that could be throughout the region, they have to serve, and once again, oversimplifying this for the purpose of time and just how to explain it, but basically, the load serving entity relies upon resources within its own geographic footprint to serve its own load. So the way this could work, for example, and what the FERC orders on this leave open is the fact that states or utilities, but probably most states, could elect to utilize the FRR construct. And what would happen under that scenario is that, let's take a state like New Jersey, because they are actively discussing it. New Jersey, even they would still be in PJM for the energy market and everything else, but they would pull out of, they would basically meet their own capacity needs for the state of New Jersey and set compensation for capacity based on only the resources within the geographic footprint of New Jersey. And I, once again, simplifying it, there are a lot of technical details on how this would actually be implemented. And in terms of questions of how compensation would be set, those are all things that would have to be developed and are being discussed. And a lot of engineering and specific questions about how that would then, PJM would still be responsible for controlling, making sure this entire overall system is reliable. But that's effectively how it works. A state could, in theory, pull out the capacity market and set its own capacity revenue, capacity compensation construct for resources in its geographic footprint. The two big issues with that, one is that overall consumer costs in that state could rise because, as I mentioned, no longer would you be getting the benefits of lower cost resources potentially throughout the rest of the capacity region. You also have a lot of benefits, economic benefits from relying on a broader resource portfolio. And some estimates are that FRR constructs, probably states that would go to FRR could actually wind up costing consumers money on a net basis. But that's something that's still being discussed and analyzed. The other big impact is that, based on some other analyses that have been done, including the independent market monitor for PJM, is that if a state like New Jersey or a few states were to pull out the capacity market, capacity prices in the rest of the RTO that still stuck with PJM, all else equal, those capacity market prices would be lowered. But so a lot still that's being analyzed here. There's nothing set yet. No states have actually developed FRR rules, but it is being actively discussed in a few states, New Jersey in particular. Illinois is another one where there's been some discussion, but in Jersey, there's been some trade precedents over the last couple of weeks where they're sort of discussing the possibility. But excellent question.
And thanks for an excellent response. Anybody else want to weigh in on that? Okay, we're going to come back with one more question. We're running out of time here, but I do want to get one more question in. In the meantime, I'd also like to do the sixth and final of the secret words, which is subsidy. S-U-B-S-I-D-Y, subsidy, is our sixth and final secret word. So attendees, you have all six now. When the survey comes, when the event is complete, fill out the survey, submit it, and you'll get your continuing education credit. At least you'll be on the road to it. And thank you for your attention to the secret words. Okay, final question is going to go to you, Rabea, and it is, what actions do stakeholders need to take regarding equipment listed in the executive order that is already in the BPS? Is there a rip and replace directive?
Good question. So the executive order does not provide any interim guidance to parties initiating transactions with suppliers between May 1st and the time when DOE will issue its regulations. But practically speaking, it's been the federal government's practice to focus enforcement on commercial transactions occurring after regulations are actually setting forth clear rules, especially for, in this context, we're talking about entities that could be blacklisted or pre-approved, or entities or equipment that could be blacklisted and or pre-approved. And so, as of now, the DOE itself has said in its question and answers on its website, the guidance it's giving to the industry is basically, as of today, no equipment is prohibited. And so, what some companies are doing, though, to prepare for the rule rollout, they are evaluating the source countries and sources of the equipment that are covered under the executive order and are being used in their generators and various other bulk power equipment types mentioned in the executive order. There are some companies that are doing that, and then there are others who are just monitoring the process, monitoring the DOE process, and keeping apprised of the rulemaking process, and have been involved in voicing their concerns through the request for information process that DOE has, and now with FERC's notice of inquiry are voicing their concerns and issues in that process. So stakeholders have that option available to them now through the FERC notice of inquiry comment period that will end in November. But that's basically it. Review, monitor the process, and wait for the rules.